Ende baye kinekwe mono zokwa. Eno bosi nke tata. Tata bo bosi 20th of December 2023. Ice from Darolin and Kunshne Serai. Ice Kwana Oya Dren Namano bosi nke ta. Only Adikechi. The child agwago. Otu ayi kwuru otu aka ya dịrị ise. Dịka o si dị na ekwere nkwa na gị na-ewetara n'update ọbụla bụ pasta maka ife na-eme n'ala Igbo. Nkwa ekwere unu a ga na-ewetara unu ya n'iru akwụkwọ. Ige ntị n'iru akwụkwọ ya afọ Mazi Nnamdi Kanu's lawyer bụ Maswell Okpara were ife okwu n'international media anyị ma achọkwu ife okwu gasị gbasata maka Simon Ekpa and the Biafran struggle. So many things so kwuru dị iche iche ma achọ m kosi m n'ọnụ pụta so eme m ga-eji wee lapụ unu kunu ga ya bụ ife na ntị unu kunu nụ ya unu ga-esi ya unu drop right comment unu na comment below gbasata maka ife iche n'ihe ndị okwu gasị n'iru akwụkwọ. Alright, over to you, Barrister Maswell Okpara. Over to you, sir.
Nnamdi Kanu's case, and also who brought about that should I say allegation or discussion last week. He is already here. Maxwell Okpara is the lawyer, and then another lawyer is joining us. First, Baba is to look at these issues. Thank you, gentlemen, and welcome.
Thank you. It's my pleasure to be here.
Thank you for having us.
Okay, let's start with Maxwell. What has happened since we had that discussion last week concerning what you termed as a new way to defraud Nigerians through the collusion of the courts, the police, and some banks?
Well, I want to first of all thank that communication for using this program to do justice to it, because your role really assisted Nigerians. I also want to say that since that incident, I have received more than 30 calls on the same matter. In fact, the one that called me yesterday, that one is very, very pathetic. His own is a 250,000 naira. He has done everything, nothing happened, so he decided to leave it for God. Because the lawyer he engaged to say that he's going to charge him about 700,000 naira thereabout. He said, instead of sending that money, let me just leave it with that. So I advised him, I said, no, this is your account, and that account you have BVM with other accounts, you better sort it out. So he's coming to see me in the office today. So these are the organized crime that has been happening with Access Bank. Now, remember that on that day, I called...
So the person that called you is still with the same bank?
The same bank. I may even bring them here if you wouldn't mind. Now, on that particular day, I accused squarely on Inspector General of Police, saying that this boy said that they are working for you and you get your own share. I also accused Chairman Police Service Commission, saying that this guy said that they are working for you, you get your own share. I accused CJ, Nasarawa State, said that the magistrate said that he is your agent, and the chief registrar. So this is an allegation, just like you said. It's not left for them to come and prove me wrong. How do they prove me wrong? The CJ Nasarawa State has proved me wrong. He has issued...
Proved you wrong?
Yes, by wrong.
Okay.
That the magistrate is not his agent. That the magistrate is on his own. So he has issued query to the magistrate because they have seen that my complaint is genuine. How can the magistrate issue an order to pull out money that is over 120 million naira? Do you have the jurisdiction? So all the whole thing I raised, there's so merit in it, together with the chairman of Jusun and Nasarawa State and the NBA, Kefi. They collectively look at it and they issued query. I think they gave them 48 hours. They must have answered the query by now. Now, I have also written to Chairman Police Service Commission. They have received their own letter. So it is now left for the chairman to prove me wrong. You can say by ordering the investigation of this. I have also written to National Secretary, Executive Secretary, National Rights Commission. They have received their own, because this has to do with rights. I have also written to Inspector General of Police. I even said accusing him. It's now left for him to come and clear himself. I have written to Chairman Police Service, Chairman Senate Committee on Police Affairs. This is their own letter. They have received it. I have written to House of Rep on a Committee on Police Affairs. This is their own. I have written to ICPC. This is their own letter. They have received it. I have written to EFCC. They have received their own letter. I have written to the CBN through the Director, Consumer Protection Department, for them to get all these syndicates in the bank and in the police, because it has been there. So this young man was able to fight his own because he has the capacity. So that is where we are now. That's
so all these people were all mentioned in that matter, the people that you have all written to?
Yes, those people now, they have a stake. Like EFCC, this is a financial crime. ICPC, you have a stake. CBN, you have a stake to protect the customers.
As a regulator of the banking industry.
Yes, the National Human Rights Commission, all of them. So let them collectively investigate the matter and get these people. And we are also using this medium to call other people to come so that they can now do it holistically. So we are waiting for their reply. They just, as I told you, it's only the Chief Judge, Nasarawa State, and the Chief Registrar, Nasarawa State, that have done the needful. That is the position as we speak. Other people were made to receive their own call, probably to call me with my client or something of that nature. And the Access Bank, of course, they don't have anything to say. They have no defense. They are sending people from the back to come. I said, if you want me to do something, write to me. Write to me so that I will have this call. You calling is unprofessional. I don't go by that.
Okay. All right. So it's just asking for full investigation into the matter.
Yes.
All right.
Okay.
So we will move on with the conversation now, but before we do that, we want to bring you a clip of an interview with Chief Dan Ulasi talking about...
let's start with you first. You listened to, Chief Dan Ayong there.
yeah,
Dan Ulasi, I beg your pardon, there. So, what do you make of this judgment as given by the Supreme Court on Friday?
Well, you see, the judgment given by the Supreme Court is nuanced. We have to be careful in commenting on the judgment in the sense that it can send a kind of blanket interpretation that is misleading. Let me explain what I mean by that. Now, first of all, Nnamdi Kanu is an innocent man. As of today, is an innocent man. The law presumes that he is innocent until proven guilty. So he has not been proven guilty, so he's an innocent man. An innocent man standing trial. So from that junction, we need to understand that the Supreme Court did not say that Nnamdi Kanu is guilty of any offense. The Supreme Court have not said that Nnamdi Kanu is guilty of the treason or terrorism charges he is being tried before the Federal High Court. Because I see a lot of persons try to comment on the Supreme Court judgment like they make it look as if the Supreme Court have already declared that Nnamdi Kanu is guilty, or the Supreme Court convicted Nnamdi Kanu. The Supreme Court didn't do that. The Supreme Court looked at several issues. One of the issues is the issue of his redemption. And he asked, was Nnamdi Kanu brought legally into the country? And the Supreme Court answered that was no. That Nnamdi Kanu wasn't brought legally into the country, according to international laws, international conventions, and what have you. But now the Supreme Court went ahead to say that the remedy available to Mazi Nnamdi Kanu is not the suspension of his trial or declaring that the Federal High Court lacks jurisdiction to try him because he was improperly or illegally rendered into the country. And I tend to agree with that reasoning because I would have taken a different position if Nnamdi Kanu was brought into the country illegally and charges were filed after he was brought into the country. But these charges we are talking about were filed before Nnamdi Kanu left the country. So where is the illegality of the trial when the trial precedes the rendition? The trial precedes how Nnamdi Kanu was brought into the country. So Nnamdi Kanu has a remedy. He was brought illegally. But the remedy, according to the Supreme Court, which I tend to agree, is not to declare that the Federal High Court lacks jurisdiction to continue the trial. I don't agree with that. Now, the Supreme Court also spoke about the bail. And I agree with the Supreme Court about the bail issue. Now, Nnamdi Kanu was granted bail by the Federal High Court and was enjoying his bail. And security forces stormed his compound. So why did you storm his compound when he was enjoying his bail? So you cannot say he has jumped bail when you are like the course he ran for his life. So I think that, thank God one of his lawyers is here. They can still apply for the bail because I think he deserves bail because he's an innocent man. The bail, they claim he jumped. It was because of the security forces storming his compound. And that is the reasoning of the Supreme Court. So when it comes to the issue of bail, Nnamdi Kanu should enjoy bail. When it comes to the issue of was he illegally brought to the country, yes, he was. Is the remedy that his trial at the Federal High Court should cease? Respectfully, I don't think so. Nnamdi Kanu should, as the Supreme Court said, defend himself. This has nothing to do with the legality or the illegality of the charges. If the charge in itself is illegal, processes should be taken to quash the charges. That's what I'm saying. We should be careful. If not, we give a blanket, comment that looks as if Nnamdi Kanu has been convicted, or he is no longer innocent, or the Supreme Court has said that Nnamdi Kanu should go to prison. The Supreme Court didn't say that. Nnamdi Kanu should defend himself. That trial is not illegal because it was rendered illegally, but he has a remedy in civil processes, in civil proceeding. He has a remedy. I think that's my take on that for now.
All right, Maxwell, you are one of the lawyers to Nnamdi Kanu. What's your own position concerning Friday's Supreme Court judgment?
Thank you very much. I want to interrogate this matter on three angles. One, the legal angle, the moral angle, and the political angle. Now, starting with the legal angle, my learned colleague got it wrong. Now, let me just give you this scenario for the common man who is watching to understand. If there is a robbery incident going on here now, and those robbers were caught by the police, and police from the premises of that communication rush straight to court to see these people we call them robbing at that communication, convict them, sentence them to court, to prison. And court said, I hereby convict you and sentence you to prison. That particular trial is already collapsed. It cannot stand. Remember that they caught them red-handed with AK-47 robbing. They are already in court. But it will collapse because the due process was not followed. What are the due process? You get them arrested, you investigate them, you arraign them in court, you try them. You conclude their case, they will open their defense, they will defend themselves. Court will now look at, review the evidence, give their judgment, convict them, and sentence them to court. These are the procedure. And while you are doing any criminal matter and you fail to observe any of the procedure, it has collapsed. Now, do you know that when you go to court and you are investigated, do everything, police arraign you, and they ask you in court, guilty or not guilty, you say, I am guilty. Court will not convict you. Ask anybody. Court will say, ask the prosecution, prove your case. Remember that you have said, I'm guilty. Of course, an ordinary person will say, since he has said I'm guilty, I convict him, now sentence him. Court will say, no, prosecution, prove your case. Now, Nnamdi Kanu, the issue of treaty that Nigeria consented, domesticated in our own local legislation, signed into law. The international treaty said there must be a procedure. The procedure is that when you arrest a fugitive in a country, the law said you get him arrested. Notify the country where he ran away from. In this case, Kenya. Notify Nigeria. Then Nigeria will now apply for his extradition. In that application, the law said you attach a copy of that charge, which you say that he's facing. You attach proof of evidence. You send it to the Home Minister of Justice there. They will look at it and arraign, take him to their own court with jurisdiction. If it's Nigeria Federal High Court, in their own Federal High Court, the law said the judge will now look at it and consider the factors. What are the factors they are going to consider? One, whether his life is protected in that country. Two, whether he will get fair hearing. Three, whether that country observe fundamental human rights. The law said after considering this thing, they discover that the person's life is not protected, it will not be protected, there is no human right, will not get fair hearing. The law said there are options for that country. The options now is that one, to try him in that country. Two, to send him in a country with a similar jurisdiction. Three, to send him in a country, probably as Nnamdi Kanu is a British citizen and Nigerian citizen, you can deport him back to the country.
To the UK.
To the UK. These are the laws. Signed into law by our own. Now, Nnamdi Kanu told me, it's not as if that because I see him every week, told me that he went to airport to pick his friends. Some people now said, is this not Nnamdi Kanu? Some police officers at that car park, they rallied him around and started beating him. This is a terrorist in Nigeria. So people wanted to do this, and they used their language to tell them that Nnamdi Kanu is a terrorist. Everybody ran away. They arrested Nnamdi Kanu, said they took him there, blindfolded him, handcuffed him, take him to a particular cell, chain him in one big generator, and under generator on with a very big light. This is what Nnamdi Kanu passed through for that 1 week. And when he was about to collapse, so they started calling Nigeria. You can, if they will allow you, go and interview him now. He'll give you this story. They started calling Nigeria, telling Nigerians that they should come and take Nnamdi Kanu. They are going to release him. According to Nnamdi Kanu, he said the police officer told him that they asked that they should kill Nnamdi Kanu. They should put him in a vehicle and set it ablaze. They said no, they cannot. So they started negotiating. According to Nnamdi Kanu, he is still alive. He said that Nigeria paid them money. So now they sent a private jet. Nnamdi Kanu from that cell, after 7 days or 8 days, straight to tarmac. And they put him in an aircraft and brought him into this country. His passport, nothing. And Malami was telling Nigerians. Now what we are now talking about, what are we talking about? It is not Nnamdi Kanu. We are talking about foreign investors who are watching. You are asking somebody to come and invest his millions of dollars in a country that does not obey rule of law, that does not obey due process. Probably if something happened to his company that he cannot run to court to seek relief, you are a joker. Nobody will take you serious. That one is on this thing. Now, I want us to look at it, because most of the times when I read the judgment, I said, is this thing what somebody like us saw? The kind of judgment we saw Oputa then that made us even to say that we are going to study law. On a moral angle, I asked myself on Friday, these judges, are they living in the moon? Not considering Maxwell, not considering another person. Their own colleagues, they're in the southeast. How many judges, how many two customary judges have been murdered? When they set up a election petition tribunal, those guys wrote them later that if we see you people sit, sorry for you. They ran away and run down to Maraba here. Election petition of Southeast was had in Maraba here, and Imo State was had in Maraba here. Now that they have finished, are you now telling us that Federal High Court, I'm not even talking about State High Court, Federal High Court that is a Federal Court, National Industrial Court that is a Federal Court, Court of Appeal that is Federal Court, there in the Southeast, do you think what will be the position of those judges? I'm from Southeast. I have one of my law firms in Imo State, and I have some matters there. The whole Imo State now, the courts in all those rural areas like Mbise, Olo, Okigwe, none of them sit. They have moved down to Owerri. Customary court in my community, Amuzi, has relocated as a result of insecurity. Now running to where? Because we are in the Supreme Court, where you have all the whole security, where you have the SSS from the gate, and you're not thinking about your colleagues there in Imo State.
Okay, so
excuse me, wait, let us get it right. There are many ways by which a judge can arrive to decision. You consider some factors. What are the factors? Security. Now you're talking about Simon Ekpa. Anybody who is telling you Simon Ekpa, in fact, has blocked everybody. I was able to get him online the other day. He said that you were joking. Nobody can talk to that young man apart from Nnamdi Kanu. Nnamdi Kanu have given me a series of messages to give him. He said that I'm joking. That all those things Nnamdi Kanu is saying, that Nnamdi Kanu is saying it with AK-47 on his head. All our effort to convince him proves about it. In fact, when I even told him that guy, Nnamdi Kanu said that you should stop that thing, the entire Igbos were already there. Peter Obi is about to win the election. At least everything will come there and say you are joking. Peter Obi will win the election, but nobody will declare him winner because an Igbo man will not be a president. And all the whole thing that he's saying is falling in. So Now, why not release this man?
Okay, I will need you to just go. You mentioned three things. You've talked about the legal, the moral. I need you to talk quickly about the political now.
But we need to take a break for social media.
Before you do that, we'll have to take a break. Okay. And when we come back after the social media, asking the Federal High Court to continue with the trial of Nnamdi Kanu. And we have with us in the studio Maxwell Opara and First Baba Isa, both of them lawyers, talking to us about this issue this Monday morning. Maxwell, you left off speaking. You've talked about the legal angle, yes, the moral angle,
and the political angle.
I'd like you to briefly talk about the political angle to this.
Yes. So the point I'm trying to make is that you cannot talk about a society without the functionality of the justice system. The justice system in the Southeast now is down. One, some judges cannot sit in some jurisdiction. They will tell the CJ, I am not going that place to sit. Like everybody now has clustered in a way. And once there is no court room for a judge to sit, he will not sit. Or every Monday, nothing happened. So when you are giving this judgment, yes, you now say that the way Nnamdi Kanu is being brought in Nigeria is illegal. You now say that it is unfair for the army to use Operation Python dance to kill people in Nnamdi Kanu's house. I think they said 38 and left with 18 cops. You also say that the judge did not follow the due process and did not consider some facts in revoking his bail. In other words, that revocation of his bail is null and void. Now you have the power, inherent power, under Section 6 of the Constitution to make consequential orders. You now make a consequential order directing that the case should be remitted back to Federal High Court. Then you did not even make a consequential order that in the interim, let that bail of Nnamdi Kanu continue. Are you saying that you don't have the decision to issue order for the release of Nnamdi Kanu? Now, if you watch, you are now saying, let it not be that I'm the person that released Nnamdi Kanu. Did I carry a problem? Are you getting what I'm saying? So now we are now going back from here. Now going to Federal High Court. We are going to go and hustle for date. Now, excuse me, we are now going to hustle for date, and no date is being given till towards ending of January. And are you now saying that people will continue to live in perpetual fear in the Southeast, including your colleagues, members of the bench, the judiciary, the judges? Now, on the political angle, just like Dan Olasi said, about 90% of the Igbos Southeast, because this is a moment of truth, believed that their son is being robbed of this political election. But INEC decided to declare another person. They believed that they have been marginalized. This is a problem. Remember that this problem is being created by the worst government of Buhari for that 8 years. Now, a Democrat, somebody who has a democratic background, somebody who acted as an Adeko, took over the mantle of leadership with the belief that it's coming to correct all those anomalies Buhari committed. Now look at where we are. And they are now seeing that you have started where Buhari stopped in marginalizing the Igbos. Appointment of political office holders, ministerial appointment. The Southeast have the lowest number. I learned that the Organize, they are going to court for that. Then and some other things. Now that you're supposed to apply, I was thinking that on that day, on that inauguration day, as we are removing subsidy, you would have ordered for unconditional release of Nnamdi Kanu, at least to calm down the problem in the Southeast. You never did that.
Wouldn't that also have been upstaging the process?
Some judges with the matter in judicial court. No. You asked the Attorney General to issue nolli prosecute. That's power to decide.
Okay.
An Attorney General that has not been appointed yet?
No, now that he has been appointed, what happened?
No, you were talking about inauguration.
Okay, now that he has been appointed, what happened?
See, can I make it?
Right. Excuse me. So the point we are talking about, there are political reasoning, moral reason, legal reason that the Supreme Court would have considered.
Okay.
And order for the
Maxwell, you are a lawyer, and you know what we used to hear. We on the other side is that there is nothing like public opinion when it comes to court matters. There's nothing like emotions when it comes to court matters, that you have to look at, the processes of the law and follow it strictly. I'll come back to you first, but I need you to respond to what First said earlier. The fact that the court of, the Supreme Court did not convict Kanu just yet. That what he did say, even though he acknowledged that his bringing, the way he was brought in was illegal, but he said that illegality in bringing him does not, prevent the trial from continuing. So just respond to that directly.
Okay, now, Labour under the Constitution has a right to protest. You, as a citizen, have a right to protest. But when you apply for protest and the security discovered that protest is going to cause insecurity, they can approach court to stop you from exercising that your right under the Constitution because of these social reasons. We have seen where court to stop NLC from embarking on the strike. We have seen where court stop some civil society group from embarking on strike because of security reasons. So now, if you read judgment of the court, of the Supreme Court, there are many ways, because Supreme Court is a policy-making court. Whatever the Supreme Court says becomes a law. When you consider some factors, especially justice delivery, if not any other thing, justice delivery in the southeast, where your own colleagues cannot sit freely. I don't want to. I believe that if you appoint somebody now to the southeast to go and be the federal high court judge or national industrial court or court of appeal, they will consider it. They will look at it from various angles, because it's only a living that will sit and hear matters.
And hear matter. Okay. First, he has raised a number of issues.
Yes,
so respond to that.
The thing is that I agree with him on the issue. Who wouldn't agree with him when he was analyzing the issue of security, politics, morality, and all of that? Okay, we're on the same page on that, and with most Nigerians. But I think that as lawyers, we should try to stay on topic, because the topic is about the analysis of the Supreme Court judgment. And I've made it abundantly clear that we should be careful. We should stop analyzing this judgment to create the impression that the Supreme Court has already convicted Kanu. The Supreme Court did not convict Kanu. Now, my little friend got it wrong somewhere. Now, when he gave an analogy or an example about robbery and taking straight to court and the court has to convict and all of that, the thing is this, I will repeat it. No fresh charges were filed against Nnamdi Kanu when Nnamdi Kanu was illegally brought into the country.
But the charges were amended at some point, right? The law
okay, what is the implication of an amendment? The implication of an amendment is that the amendment dates back to the original charge. So the amendment does not start from the day it was amended. It starts from the day it was filed. So in law, it's clear, Maxwell know that the charges were filed before Nnamdi Kanu was illegally brought back to the country. We agree on something. We agree with the Supreme Court, we agree with the Court of Appeal. I agree with Maxwell agree with me that Nnamdi Kanu was illegally brought into the country. Now the question is, what is the remedy? It is a remedy that is a lot of, it's like it's causing a higgledy-piggledy. The remedy, the Supreme Court say, and I agree, is not to invalidate the trial. So everybody thinks the remedy is that the trial should just cease. A trial that had been existing before it was rendered to the country.
But the man was enjoying bail before, security officials went to his home.
That is what I'm saying.
Attacked the home before he jumped that bail in question.
That's why we should do what the Supreme Court did. What the Supreme Court did was that the Supreme Court picked this issue. I said the issues are nuanced. We pick them one by one. Now, one. Was Nnamdi Kanu illegally brought to the country? We say yes. Is the remedy to invalidate the trial? We say no. Secondly, the issue of bail. The issue of bail, Nnamdi Kanu was made to flee because of what? His compound was attacked, and the Supreme Court agreed with him. And the Supreme Court said no. You cannot just sit down there and revoke his bail.
So what's the punishment for those people who make if you're holding somebody for an illegality that was committed, and then you also committed an illegality, what happens?
This is where we agree. Now that's what I'm saying. We have to be, I keep repeating, we have to be careful not to jump with this thing to the basket and shake it. Now, when it comes to those who now invaded Nnamdi Kanu compound, I think they should be, I know it is proper, it is legal, they should be fished out and brought to book. But the issue here, let's go back to the main issue. Should Nnamdi Kanu's trial be invalidated because it was illegally rendered? That is not the remedy, because that trial existed.
It will seem like you're building on it.
Maxwell, just hold on. Just hold on, Maxwell.
Legality, because now, okay, let me quote my learned brother. He was saying that there's a procedure. You are arrested, you are investigated before you are taken to court. He said that here. I agree with him. So that procedure, that processes were complete. Nnamdi Kanu was already standing trial, granted bail in that trial before he flee because his compound was invaded. He was illegally rendered to face an existing trial. Now, the process of bringing him is wrong. Is his remedy to invalidate his trial? No. There are other remedies. The Supreme Court listed them, especially in civil. Now, if we take it into the emotional angle, it's not even emotional angular fact, but you know we can get emotional about it, about the insecurity. I know what he's saying. People, even if you send me to Imo State, I won't go and sit. Even some places in the north, I know that. But we shouldn't mix it up in a basket, in a bucket, and just shake it. I just mean that, okay, because there's insecurity in Enugu State, there's insecurity in Adamawa State, then the trial should be invalid. That is not the position of the law. No. That's not the position of the law. So, hold on, please. So, the thing is this. Nnamdi Kanu, I say it, let Nigerians listen. Nnamdi Kanu, as of today, Nnamdi Kanu is an innocent man. There is no court anywhere that have said that Nnamdi Kanu is guilty or has convicted Nnamdi Kanu. Nnamdi Kanu should face his trial. Nnamdi Kanu, if the charges are not legal, if those charges can be quashed and they can be set free. And the Federal High Court that revoked Nnamdi Kanu's bail, the Supreme Court said it was wrong. And I agree with him. I don't know why the Supreme Court didn't just, allow him to go on bail. But they can apply now and say, based on the judgment of the Supreme Court, Nnamdi Kanu should enjoy his bail. An innocent man is being held, is entitled to bail, should enjoy his bail. But his trial cannot be invalidated on the ground that it was illegally rendered. That's not the law. That's not the law.
Please.
Yes, you won't have more than that anyway, because we're completely out of time now.
Yes, see, what you are talking about is Nigeria, not even Nnamdi Kanu. What you are talking about is international law, which you are a signatory. You participated in it. What do I mean by international law? I just came back from London. We have 75 years of Declaration of Fundamental Rights, where Nigeria is a signatory. That is to say, if you are violating the fundamental rights in Nigeria, you are violating that law. Nigeria did not make that law. It was made internationally, and Nigeria now domesticated it in our own local legislation. It becomes part of our law. Extradition law is there that says, read the Court of Appeal judgment. Read it very well. If you read that Court of Appeal judgment, they address this issue. It's a Supreme Court judgment, whether we like it or not, nobody can set it aside.
Okay,
but you have the right to criticize it. And what we are criticizing is that now that the extradition law said, these are the procedure for you, even if that person is facing the highest crime. If you fail to observe this, excuse me, the council.
All right, Maxwell.
It cannot stand.
We are going to have.
The person, we are not going to Federal High Court. Will the Federal High Court give us date to hear his bail application?
Maxwell, we're going to have to leave it at that, gentlemen. It's a very contentious issue, really, but we have to leave it at that for this conversation this morning. Thank you very much, gentlemen, for joining us. Learned colleagues, having a go at each other here, looking at the Supreme Court ruling concerning Nnamdi Kanu, asking the Federal High Court to continue with his trial. That ruling was given on Friday. Maxwell Opara and First Baba Isa lawyers, both based in Abuja here. We thank you very much, gentlemen, for joining us.
Thank you very much.
And by a kenekwen moon ọzọ ọfụma dịka unu ji wepụta oge unu wee gee ya bụ ife Maxwell Okpara kwuru na n'iru akwụkwọ na AIT. Kedu ka ịbịa bụ ka ife nwere ike ikwu gbasịta maka ya bụ ife ụgasị ife ọkụwagasị dị iche iche gbasịta maka ikpe nke ekpere na gbasịta maka Simon Ekpa, Mazi Nnamdi Kanu and the Biafran struggle. Ya bụ ife ka anyị jikọtacha ọnụ wee tinyere unu ya wee lapụ unu kunu nke ya bụ ife unu ga-esie ya mana unu ekesigo n'yanụ ka ife unu nwere ikwu dịka gbasịta maka ife unu gasị Barrister Maxwell Okpara kwuru n'iru akwụkwọ. The lawyer need to present also one of the lawyer need to present Mazi Nnamdi Kanu on the court. in the Nigeria. So careful when the cake basta maka ya bife drop on ya on the comment section below. Nke di kibi achitekwe ni ya kwa Eastern News 24. Kai si wene wetere nuko ozi ya doke mba. Alright, that no ine no munem one kemesi ya no mibo.